Aye. Good afternoon, Mr. Wooster. This is Judge Middleton, and I'm going to arraign you on a case where you failed to show up for your pre-exam conference. The file number is 26190FY. Your attorney in that case is Mr. Paul Gibson. He's here with me at the courthouse. I asked him to be here for this arraignment. Also present is Mr. Gary Gabriel from the prosecuting attorney's office. In that case, Mr. Wooster, you're charged with possession of methamphetamine and possession of appears to be cocaine. Date of offense was allegedly February the 5th. You posted a $15,000 surety bond. When released on that bond, you were set for a pre-exam conference on February 17th, and you failed to appear for that. The court issued a bench warrant and did a notice to start the forfeiture of your bond. I understand you got arrested on the 24th and have some additional charges pending. We're going to get this case back on track. I'm going to set the pre-exam conference in conjunction with your new case, which is, Paul, are you available next? It's short notice. It's next Tuesday, March 3rd, but that's when the pre-exam is in the new case.
Yes, I am available.
All right, I'll set pre-exam conference for 3/3/26 at 8:30. Set preliminary examination if needed for 3/10/26 at 1 o'clock. Mr. Wooster, you're bound over to circuit court on an earlier methamphetamine charge from July. I just lost your case. File number.
File number is 25-25820 FH, Your Honor.
Yes, thank you. Then there's this case, which is 26190. Then your new case is fleeing, eluding a police officer, assaulting and resisting a police officer, possession of methamphetamine, and a habitual offender. My inclination is to increase your bond from $15,000 to none. Just deny the bond. I also understand there may be a hold on you from Cass County. Mr. Gabriel, you got an additional input on that?
Yes, Your Honor. Obviously, I'm here because our concern that methamphetamine seems to be driving his criminal behavior. Even though he can post some money to get out on bond, he turns right around and gets back into the meth. And this case, the one that occurred on February 24th, has a lot of similarities to the one that occurred that's already up in circuit court. And that involves him deciding he's not just going to pull over and take his medicine, he's going to run. This was an extensive chase through the county by the sheriff's department, speeds hitting up to 90, 85 miles an hour. Fortunately, no one was hurt, except he crashed his car into a tree and then ran and got tased. Clearly, he's a flight risk. He can't follow the court's instructions. So I think that, and I'm not sure, but I think maybe he was arraigned yesterday on that charge.
I believe that's correct. That's why the bond in that case,
100,000?
75,000.
Okay.
I'm inclined to do no bond.
Thank you.
Mr. Gibson, that may be a moot point. It does put some pressure on the prosecutor to resolve the case, but bond can always be amended either at the pre-exam, the prelim, or the circuit court arraignment. But in light of all the circumstances, bond is denied. We didn't end up forfeiting your bond because you got picked up again. So that $15,000 you posted with a surety company will just go back to them. But for purposes of this, both of your hearings are set for pre-exam conference next Tuesday. Mr. Gibson represents you on the February 5th case. Mr. Tim George represents you on the new case. And I don't know why they keep doing that. We've been working with the Indigent Defense Commission to appoint the same lawyer on the same defendant, but they're still working on that. Anyway, you can't go anywhere, any place where, because there's a hold on you and you got a high bond in the other case. So this matter is set for next Tuesday at 8:30 a.m. for a pre-exam conference.
Thank you, Your Honor.
And Mr. Gibson, thank you for being here on short notice. All right, Mr. Wooster, see you on Tuesday. Paul, I sent you those emails about Christopher Pontius. And he's kind of half in and half out. The notices the court sent were sent to the wrong address. We gave you the right address, but I don't know whether he got a notice. I listened to the video, or Laura did. We never actually excused you as counsel. One option, we'll have to reset it unless the prosecutor simply recharges it as civil infractions. If they are civil infractions, he wouldn't be entitled to court-appointed counsel or a jury trial. But we'll cross that bridge when we get to it. But have you had any success in getting in contact with him?
I'm pretty sure that I called and left a voicemail. Nobody picked up, but I was, from my memory, able to leave a voicemail. So hopefully he'll get notice that, he doesn't have to appear next week, I guess.
All right, well, we'll see how that plays out.
I don't know if I'll be here that day, but I guess.
Well, all right, you don't need to come all the way over here on the off chance that he'll show up, because we won't be doing it. But Angelique, I talked to Jordan. She tells me that you two have been working on her case, and you and Tim have been working on his case.
Yes.
So thank you very much.
You're welcome.
All right, Ms. Wallers-Penner, would you come up, please? Good afternoon.
Good afternoon.
Are you Tracy Ellen Wallers-Penner?
I am.
Of course, I know you, but I have to identify you for the record. You're here with your lawyer, Jordan Harden. Also present is Angelique Camfield from the prosecuting attorney's office. This case alleges a domestic assault that allegedly occurred in October on the 18th involving your daughter. The matter is set for what's called a final pretrial here today. Ms. Camfield, what's the status here?
It's my understanding after speaking with Ms. Harden that the defendant's going to enter a plea of guilty as charged. There will be no deferral.
That's what you just told me.
If necessary, I'm willing to do a no contest.
Let me talk about this, Ms. Wallers. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. If you plead no contest, you have to take your gum out.
Oh, sorry.
There's a clean.
I meant to before.
You don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. And I'd get the factual basis from the police report or affidavit of probable cause or something else. Do you understand that?
I do.
And are you going to plead no contest to this charge?
Your Honor, we had spoken in the hallway with what Ms. Camfield indicated to me she was planning to recommend to the court as far as a sanction. My client indicated she had no issue with the probation if ordered. I don't know if I don't know where she got the understanding that she wouldn't have to enter any kind of plea today to get on probation. So the offer is you plead guilty or no contest to the domestic violence charge. The prosecutor has indicated to me they're going to make a recommendation for probation with some deferred jail time and some potential treatment for substance abuse, alcohol abuse of that nature. So that's the offer today. If you choose to accept it, we'd enter the plea today, come back at a later date for sentencing. make our argument, provide any evidence we wanted to the court to try to mitigate your sentence. If not, then we leave the matter on for jury trial.
Okay, so it doesn't make a difference if I say guilty or no contest?
No contest, correct, yeah, no contest if you don't have a clear memory of what happened.
I will enter that plea, no contest.
You will plead no contest?
Yes.
All right, let me ask you a couple things. Did anybody threaten you to get you to plead to this?
No,
Promise you anything?
no,
Do you understand that if you do plead to this charge, no contest, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that? There will be no trial if you plead no contest.
I understand what you're saying. I didn't know that that was the same as guilty.
Well, it results in a conviction and then a sentence where I could put you on probation. But I don't have authority to do anything to you unless there's a conviction, either by plea of guilty, conviction at trial, or a plea of no contest. So if you do plead no contest, there won't be a trial. Do you understand?
Yeah, okay.
Or if you had a trial, Miss Harden would be there with you through every step of it. You'd also have a right to hire a lawyer of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not have a right to testify and did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. Understand?
Mhm.
A man named Mr. Rhodes was here last month and then earlier this week, and he told me, you don't look people in the eye enough. He said, you're always looking at the damn screen. And I guess I'm guilty as charged. So I've been trying to, instead of looking at the screen over here, looking at the actual people. And so, Mr. Rhodes, I'm trying to do better, looking people in the eye. All right. There is an affidavit of probable cause in here, Ms. Wallers, and I saw it and my heart sank. Your daughter Brielle says that you had assaulted her. Her mother was very drunk and her mother came in and yelling at her, asking for smokes. And then there was an argument and you pulled her hair and then some other struggle and you fell on the couch and it was unpleasant all the way around. But that's a sufficient factual basis for me. Is that acceptable to you, Ms. Campfield?
Yes, Your Honor.
Jordan?
Yes, Your Honor.
That affidavit was prepared by Sergeant Jeremy Marsh of the Sturgis Police Department.
And Your Honor, I could just I believe the affidavit would reflect that this happened on October 18th, 2025 within the County of St. Joseph.
Yes, thank you.
Thank you. I would make it a little bit of an unusual request. Because the defendant is on bond and not supposed to be drinking or using any illicit drugs, she does have an extremely severe alcohol dependency. After this particular incident, when they located her, she was at a 0.32 blood alcohol level. And I've received information from the family that subsequent to that, she was also found unresponsive at home, and when taken to the hospital, had a blood alcohol of 0.57.
Oh my, 0.57?
So that most likely why she was unresponsive would have been most assuredly alcohol poisoning at that point.
That's the highest
I would
level
like
I've
her
ever seen.
tested today.
I don't have anybody to do it. She'll have to either go to Three Rivers. Autumn's not here today.
Darn.
She's at a training conference
Okay.
and she's the only one certified to take a sample. Are you?
Just PBTs.
All right. Well, we could do a PBT.
That would be, if that's what we can do, that will
Now,
take.
I know Miss Waller, and I know that Penn Waller, she was in my sobriety court program. And I spent a lot of time with her. She's an intelligent woman. And that was a few years ago, maybe 8 or more.
It was like.
How long have it been since you relapsed?
Oh, it's just been within this last year.
So you've been sober for 6 years?
15. Was it 2015?
Well, I can look at-
2016, and so 6 years, something like that.
Let's get a PBT. Do you have one here? I think we do. Probation has one. If anybody knows where anything is after the flood. So I know that you can be sober, but this is like danger zone.
Your Honor, if I may request the court also, I think this is one of those occasions where we would need a PSI for a domestic violence charge of this nature.
All right, I'm not opposed to that. Who is Bill Hack to you?
My stepfather.
From the appliance store?
Mhm.
I've known him for years and years and years. Are you employed?
I am not currently
Where were you employed?
at Meyer.
As I said, when I knew you, you were a very intelligent, capable person when we got you sober. The law requires that I adjourn the matter at least 10 days to provide notice for the complaining witness to be here. The problem is if I do a pre-sentence investigation report, it's going to take longer than 10 days to do that. There's a no contact provision. Who's out of the house?
Riel,
So you're in your own house and she's staying somewhere else.
she's with her aunt, yes.
Who else is at your house?
Her father, Stephen Penner,
And she's your stepdaughter?
biological.
Biological daughter, okay.
My understanding is the no contact is no assaultive.
Yeah.
Well, let's take a look.
That's what the bond conditions I have reflect.
All right, well, let's see. Struggles, no contact entered. As victim is 17, they lived in the same house since the incident, no problems.
Right, the
So-
pretrial release shows provision.
So
R.
there is not a no contact provision, and somebody went the extra mile to let me know why they called it that way. So the conditions you do have personally appear for every hearing, abide by any judgment, do not commit any crime while released, make reports as directed, do not use alcohol or controlled substances, do not purchase or possess a firearm, do not have any assaultive behavior against this person who is a minor. But there is not a no contact provision. But the fact that she's probably staying somewhere else. The problem is that when you have an addiction to this extent, when the judge says, don't drink anymore, you can't just turn it off like a switch. Your body's screaming for alcohol. And so you need to do something about it. Are you in any sort of treatment right now?
I am looking to start some counseling, but I've also had a huge medical mystery that we finally just got solved, and I started treatment for it 2 days ago.
Well, I'm considering medically assisted treatment for you. But do we have a PBT here?
We do not, but we could call Centerville Constantine if you wanted us to do that.
Would you please?
Yes.
Tab, do we know where probation's PBT is? We got flooded downstairs and probation is in the wind. One probation aide, they're working remotely till we get their new office space ready across the street. Well, let's pick a date for the sentence. I'm pleased we were able to resolve this. But at one time you were active in AA, you had a sponsor, you had individual treatment.
Yes, it's still downstairs, but it hasn't been calibrated in a long time.
And none of the three, nobody knows how to use it, so. All right, we'll get some assist here. That's our benchmark. Shana gets that.
Thank you.
Thank you. Tracy, I've heard stories of very high blood alcohol levels like that. They had something in Detroit they called the 700 Club. The people that had a BAC, but they were all deceased. That was in their autopsy. And that's generally where 5.7 is. It's in an autopsy report.
Well, and Your Honor, I would just state that's, hearsay that's been provided to the prosecutor. We don't
Yeah,
have
it
any
isn't
verified
evidence in
proof.
this case, but it's frightening. Now, the prosecutors declined to do a deferral in this case. I don't know if you had a previous domestic violence, but I can only do the deferral if the prosecutor consents.
Dispatch have something to sign.
All right.
Take care of that for us.
So today is February 26th. Jordan, are you available Monday, March 30th at 10:30?
Yes, I should be able to make that work.
Anyway, you know how to go to an AA meeting.
Oh, yeah.
When's the last time you went to one?
It's been a while, but I had gone 15 years straight. Unfortunately, my sponsor died. So
The common denominator in sobriety court people that relapse is continuing to or failing to stay in AA.
And part of it, Your Honor, was I was the lead in bakery, and I could work from 6 a.m. till whatever, or noon to 8:30. And we weren't getting our schedule till a couple days before the new week. So even making a doctor's appointment was almost impossible.
All right.
It was
Well,
very difficult
You,
to have a
my
reliable
hope for
schedule.
you was that you would have been somebody else's sponsor. Did you sponsor others while you were in?
I helped others. I wouldn't say I officially sponsored them. I was dealing with, work and Brielle and
I believe your previous probation officer was Gina Wagner. She was excellent, but she's no longer with us.
Can I comment that the other charge that they say I have
Let's take
was from that 2015 DUI?
3. All right, let's take a look.
The basis for not offering the deferral was that
Oh,
OWI conviction had
Well-
tag along child abuse
oh,
with it.
well, that's in their discretion. I do remember that. Now, we've learned that if you do an OUIL and child endangerment alcohol charge, it prohibits you from getting an interlock device. We've got a guy in sobriety court right now who's doing absolutely great, and he can't get an interlock. So what they were doing back then was taking an OUIL and then a child abuse neglect charge, which wouldn't affect your driving privileges. So if you get the motor vehicle charge under 257 with a child in the car, they will not allow you to get a restricted driver's license with an interlock, even if you're in sobriety court. And we knew this a long time ago, and we've known it for a long time. So very often they will take that charge out of the motor vehicle code and put it under the penal code, a misdemeanor child abuse attempt or something. So that doesn't affect your ability to get an interlock.
Cap said we could get a road officer. Come over.
They've summoned one.
Yes.
So that allowed you back then to get your interlock. But so it does show as a child abuse, but it was Brielle the child that was in the car?
Mhm.
Oh my. All right. Set for sentence March 30th. Is the PBT going to show alcohol in your system? Could. Now, you're not to use any drugs or any alcohol. The drugs include marijuana, which is lawful for adults to use for recreational purposes. But while you're on bond and probation, we prohibit it. You can take any prescription medication that's prescribed, anxiety medication, pain medication, antibiotics, whatever, you can take that. But unless it's prescribed by a doctor. And I'm serious, it's very, very difficult to just stop. If it was that easy, you would have already stopped. Now you got me hanging jail over your head, which is an extra impetus to stop. But you need to do something. You need to get back into AA. You need to get plugged in with somebody at Pivotal or somewhere else. Perhaps get some medical assisted medication. But you aren't going to be able to hold your breath. Now, what I have envisioned here, the prosecutor is looking for some substance abuse counseling. There's also the women's anger management program, which you're probably going to be put in. But you could get a head start on this by getting your counseling set up in advance between now and March 30th. We had some bumps in the road, I remember, but you did actually complete the program and graduate.
Yeah,
Yes.
it was because my creatine was always low, so which equals positive, and
Mhm.
so I spent many a weekend at the country club.
Well-
and I found out that it is abnormal low all the time, has been for years. Still, I have a thing from every time I've been to Brunson Hospital, I had some surgeries, they've documented it, and it's always low. It's always diluted.
Well,
Also from the type 2 diabetes.
and I don't know if we knew about type 2 diabetes back then,
No, at the time Sturgis Hospital said no, but I ended up going to Fort Wayne and
because we did look into it. you kept having diluted tests, and we've struggled for the entire tenure of sobriety court with dilutes.
Yeah.
And we discussed this 10 years ago. Many programs, a dilute was an automatic jail sentence. Swift and Sure, some of the other ones, a dilute was just assumed to be an attempt to mask the results. And so we do a few, we do some sanctions, then there'd be jail, and then you get out. And I remember we had one guy in particular who we finally did discern he had a serious kidney problem. And he started to get treated for it. He did graduate. All right, we're waiting for local law enforcement. I know Centerville and Constantine share a jurisdiction, so sometimes the Centerville officer's in Constantine. All right. I'm going to ask you to step out with the officer, take the preliminary breath test, and then we'll send you out to the counter to get set up for your appointment for the pre-sentence investigation. I can remember things that happened 10 years ago. Just can't remember what happened yesterday. Very good.
Thank you.
Tracy, that's a good sign.
Your Honor, the drinking was more of like a binge thing. It was not a daily occurrence.
Well, you're binging to the point where you're almost killing yourself. So I don't want you to drink anything.
Okay. I just wanted to let you know that.
All right. But you have to develop a tolerance to be at the level 3s and certainly to be at the other level. So Jordan, I'll ask you if you take your client out to the counter, we'll get her set up for appointment for pre-sentence interview. The sentence will be March 30th at 10:30. Any treatment stuff you get set up before that, bring it, share it with your lawyer because I want to know about it. All right, thank you.
Great.
All right, Ms. Canfield, thank you for your help. We have an important appointment. Yes, well, we'll put that in the file.
Had it signed, but we went over it anyway.
At 3 o'clock for Deputy Metz's wedding.
Oh,
Frank asked me if I would marry him on 262626.
all right.
All right. We will, Jordan, thanks for your help.
Thank you, Your Honor.
Who was the officer that came? I didn't get a chance to tell him thank you.
Oh, I don't know.
What was that?
Who was the officer that was here?
Deputy Raymond.
Okay, I didn't get a chance to tell him thanks. I will stop the live stream and we will be back.
As the hearing moves forward, the courtroom atmosphere becomes more complicated than anyone expected. The judge begins carefully untangling the timeline of events surrounding the tenants, the escrow money, and the series of legal disputes that followed. At first glance, it seems simple. Tenants moved out of their original units and relocated just across the road. But legally, things are rarely that straightforward. The judge explains that many of these tenants didn't just move buildings. They moved into a completely different jurisdiction in Ypsilanti Township. They stayed there for a period of time under various agreements with a new landlord. And that's where the legal confusion begins. According to discussion in court, some of those agreements were unclear, and even the judge admits parts of the situation are difficult to follow. Then things escalated. The new landlord eventually filed lawsuits against some of those same tenants. Now the court faces a much bigger question. Do those lawsuits still exist? Are there active cases still pending in another court? Because if they are, that could directly affect how this court handles the escrow money that was originally deposited. In other words, if another court already has authority over a related dispute, this court must proceed very carefully before releasing any funds. That's why the judge pauses the discussion and makes something very clear. Before the court can decide anything about the escrow money, the timeline of these events must be fully understood. Were the tenants still under obligations from the first property? Did the new landlord file claims that are still active? Or have those disputes already been resolved elsewhere? Until those answers are confirmed, releasing escrow funds could create conflicting legal decisions between different courts. So for now, the judge chooses the safest path, requiring formal motions from the tenants before any escrow money can be released. That way, every claim, objection, and financial record can be reviewed on a case-by-case basis. It may seem slow, but in court, careful procedure is often the only way to prevent bigger legal problems later. Because when multiple landlords, courts, and contracts collide, even a simple housing dispute can quickly turn into a complicated legal puzzle.